Hello, and welcome to Schiff Hardin's webinar, A New Administration, What's in Store for Employers? We are pleased that you have decided to join us for this important topic. A copy of the presentation can be found in the handout section located on the left-hand side of your screen. Questions can be submitted at any time by using the chat feature in the lower left-hand corner of your screen. If time allows, our speakers will answer the questions at the conclusion of today's presentation. If we do run out of time, the speakers will follow up after the presentation to answer your questions. I would now like to introduce today's speakers, Hank Sledz and Lauren Novak. Welcome, Hank and Lauren. The floor is yours.
Thank you. And welcome, everybody. Thanks for joining us today. Lauren and I look forward to spending the next hour or so with you. Before I get into the substance of the presentation, though, I do want to note that there's one change in the program materials that you saw. That listed Lauren as an associate of the firm. I'm very happy and thrilled to announce that effective January 1st, Lauren has become elected into the partnership of the firm. And those of you that have worked with her in the past know that it's well-deserved. So just wanted to note that before we get going. But with that, let's talk about what we may see in the new administration in the area of labor and employment issues. And obviously, I think we could all agree that the campaign in this election has been very unusual, probably the most unusual election and campaign that we'll see in our lifetime. And it's been unusual in the area of labor and employment issues as well, because as contrasted to prior campaigns, there really wasn't a lot of discussion about specifics as it related to labor and employment. You can contrast that to the campaigns in which President Obama was elected in 2008 and 2012, where it was pretty clear what his agenda items were, what some of his thoughts were, and it was clear that it was going to be more of a worker and union-friendly administration. In this campaign, there weren't as many specifics discussed. Now, it is true that President-elect Trump generally talked about improving the economy, and as a result of an improved economy, he'd hoped to create more jobs, increase wages, and enhance job security. But he didn't really indicate how he was going to do that other than three cornerstones, and that was corporate tax cuts, a revision or repudiation of what he views to be unfair trade policies, and then less government regulation. So those were the general cornerstones of what President-elect Trump wanted to do with the economy. What made it interesting and in some respects harder to predict where the administration is going to go is that at times the President-elect's positions were moving targets. For example, with the minimum wage, at various times throughout the campaign, he either supported or opposed a federal minimum wage. In some situations, like immigration, as Lauren will talk about in a little bit, his position moderated. So, again, it was difficult to get a real lock as to where it was going. Now, of course, in the Trump administration, he is going to benefit from the fact that the Republicans control both the House and the Senate. So, as he formulates his agenda and comes up with his policies, it may be a little bit easier for him to get it through on a legislative basis than it was for President Obama, who faced a hostile Congress. One thing that we know for sure is that based on the appointments that we have seen, or the anticipated appointments that we've seen so far, agencies such as the Department of Labor, the EPA, the Department of Energy, the Small Business Administration, it's clear that President-elect Trump and his appointees are looking to make some radical changes from the policies that were part of the Obama administration, not only in labor and employment, but in areas as well, other areas as well. So what we hope to accomplish today is that Lauren and I will give you our best guesses as to where we think labor and employment issues are going to go under the Trump administration, but being lawyers, we'll give you the disclaimer that all it is really guesses. It's our best guess as to what's going to happen, and we hope that our predictions are accurate, but we can't guarantee it. One thing that we would suggest before we get into the substance of our discussion is that since we anticipate that there are going to be some major changes coming and they're probably going to happen fairly quickly after the inauguration, please feel free to continue to check our website under the Labor and Employment tab, because we will be updating as policy changes occur, new regulations come in, or other actions are taken by the administration. So with that, I'd like to turn it over to Lauren. She's going to start us off with immigration, which is one of the areas that was obviously a keynote of the President-elect's campaign. Lauren?
Okay, so immigration is one area where, at least up until last week, we've had some sense of where the President-elect was going, but through some interviews that he's given over the past several days, it appears that his strong stance on immigration may be softening at least just a little bit. One area where he does appear to be softening is the position that he'd taken on DACA, which was what it stands for, the Deferred Action for Childhood Arrivals, and was implemented through an executive order by President Obama. Essentially what it does is it shields young people from deportation if they are students, in the military, working, and who are otherwise law-abiding citizens. You're often going to hear to them in the news referred to as the Dreamers, and what we know right now is there's approximately 700,000 young immigrants who are in this program. During the election, the President-elect had said that there would be absolutely no amnesty for illegal immigrants, and presumably that included these Dreamers. But just last week in a Time magazine interview, he said that he was going to, quote, work something out that's going to make people happy and proud. So again, it does appear that possibly he's going to take the Dreamers into consideration and maybe soften his stance there. Interestingly, there's a bipartisan bill that Senators Graham and Durbin presented to Congress last Friday, and that bill aims to protect Dreamers from deportation. It's called the Bridge Act. The bill would essentially protect them from removal and also, at the same time, grant them work authorization while they remain in the United States. There does appear to be some bipartisan momentum for this bill, and while it won't pass during the current session, it's possible when the Senate reconvenes in January that we could see a bill of this nature pass through Congress. If a bill such as the Bridge Act doesn't pass, there's also been a call for President Obama to pardon the Dreamers before he leaves office. The White House has taken the position that it doesn't believe it has the ability to pardon the Dreamers because illegal immigration is a civil penalty and not a criminal penalty, and traditionally pardons have been used for criminal penalties. But Democratic members of Congress have argued that his ability to pardon through executive order is not just limited to these criminal penalties, and that he should take that avenue for assisting the Dreamers. So that sort of remains to be seen whether Congress or the current president will override Donald Trump's intentions with respect to the Dreamers. Another area where the president-elect has been very vocal is that he wants to deny visas to immigrants from countries where adequate screening cannot occur. As of right now, the government has the authority to deny visas to those deemed detrimental to the interests of the United States. We expect that a policy of denying visas to immigrants in such countries where the adequate screening cannot occur would impact immigrants from countries like Syria and Iraq, but could also include other countries such as Libya or Turkey or Egypt, where we often see individuals from Muslim backgrounds coming into the United States. We may also see increased investigation of employers who use H-1B visas. The H-1B visas allow U.S. employers to temporarily employ foreign workers in specialty occupations. So generally, this includes occupations such as engineering, math, and business. And a limitation on the use of H-1B visas would detrimentally impact the technology industry. Right now, the employers that are mostly using H-1B visas are within the technology staffing industry, and primarily those individuals are coming from India. Originally, the president had had vowed to end the H-1B visa program, but over the past several days, we've seen his position on the H-1B visa soften just slightly as well. So he's acknowledged that the U.S. needs foreign workers, but has said that they're going to be admitted to the United States based on their merit. So at this point, we're not really sure how that will be quantified, but it does appear that he does acknowledge that individuals coming in on H-1B visas will be necessary to the American economy. Interestingly, Trump's Attorney General pick, Jeff Sessions, is a longtime opponent of the H-1B visa program. For those employers who do use H-1B visas, we could see an uptick in investigations of those employers by the Justice Department if it believes that employers are discriminating against American workers by choosing to hire H-1B visa workers instead. Another area where we could see increased investigations of employers, and interestingly, with the Trump administration, we anticipate in most areas less employer investigations and less regulation of employers, but this is really one of the areas where there will likely be an uptick in regulation. We could see additional investigations by ICE who will conduct I-9 audits of employers. Another area where we may see some change is with the EVerify program. As of right now, it's not mandatory for most employers. There are approximately 650,000 employers who are enrolled in the program, and the President-elect has previously said during the campaign that he's going to make EVerify mandatory to protect jobs for American workers. There could also be an elimination or hold on the issuance of green cards to foreign workers. Essentially, what green cards are permits that all foreign nationals need to live and work permanently in the United States. Trump has said that he will put on a hold on issuing these green cards so that U.S. employers will have to hire from a domestic pool of unemployed immigrants and unemployed native workers before being able to access individuals with before being able to get individuals into the country with green cards. And finally, the last area where we may see some change is with the TN visas. These are essentially visas that are granted under NAFTA and apply to employees coming from Canada and Mexico to permit them to work in the United States. Trump has said that he wants to either renegotiate NAFTA or pull out of it entirely if the United States doesn't get favorable terms upon the renegotiation. So if the renegotiation were to occur and the TN visas were to be modified or eliminated in some way that could impact U.S. employers, and of course if the United States pulls out of NAFTA entirely, that would impact those employees who are in the United States currently under the TN visas. So that's where we anticipate immigration going, and I'm going to hand it over to Hank right now. And he is going to talk about the Affordable Care Act.
Very good. Thanks, Lauren. Just as immigration was front and center during the campaign, so was the repeal of the Affordable Care Act. I think we all recall that throughout the campaign, Trump vowed to repeal Obamacare as of day one. We recognize, and I'm sure he does as well, that that's not within his executive power to do so. But it is clear that this is going to be a priority agenda item. In fact, Senate Majority Leader McConnell has stated that this is the first item on his agenda for the new session of Congress. And obviously, with the Republican majority in Congress, there are going to be changes. Just like in immigration, though, there's been some moderation by President-elect Trump as it relates to the Affordable Care Act. Initially, he talked about a complete repeal, and we do expect that there are going to be legislative efforts, most likely successful, to modify major elements of the ACA, such as the coverage mandates and penalties for refusal to get coverage. But where we saw some moderation would be that some of the elements apparently are going to be retained, particularly items such as the coverage for children up to the age of 26 and coverage for pre-existing conditions. So we expect that to happen, but we really don't have any good idea as to what is going to be proposed to replace the ACA. Obviously, one of the suggestions is to allow insurance companies to cross state lines in the hopes that that's going to spur competition, lead to better options in terms of policy coverage and lower premiums. That idea has been floated numerous times over the years, but right now at least there are restrictions on the sale of insurance across state lines. So that's one thing that's being looked at. In addition, in June, the House Republicans suggested a plan to replace the ACA, and that may be the framework that will be used by the new administration. Those suggestions included things such as block grants to the states for Medicaid coverage, the use of tax credits to cover the cost of insurance premiums and out-of-pockets, and then the expanded use of health savings accounts. So those are some of the items that we may see if, in fact, the ACA is repealed. One thing that's interesting is that although it's clear that the Republican Congress and President-elect Trump want to make major changes to the Affordable Care Act, it's kind of unknown how quickly that's going to happen. Despite the fact that Majority Leader McConnell called for this to be a day one priority item, he recently refused to give a timeline as to implementation of any replacement. And Speaker Paul Ryan, on an interview at 60 Minutes a week ago, said clearly that the repeal and replacement will not happen overnight, but there may be as much as a 2-year transition period, which has led to some conjecture that perhaps the Republicans will vote for the repeal of the ACA fairly early on in this congressional session, but delay the implementation of the repeal until after the midterms in 2018. That way, if things go bad, they don't have a real problem politically because the midterms would have passed. There's also been some conjecture that the Republicans might just let the ACA collapse under its own weight. We know for a fact that United Healthcare has already pulled out of the program, and we continue to see that many other insurance companies are threatening to do so based on the high cost of having, unfortunately, mostly sick people applying and getting into Obamacare as compared to younger, healthier individuals who have not. So that would be another way that the Republicans could perhaps avoid some political fallout by letting ACA just fall apart on its own. So at this stage, it's clear that there will be changes. It's clear that this is an agenda item that has priority, but we're going to have to take a wait-and-see approach on this to see exactly what's proposed as a replacement. Lauren?
So the new president's also going to have the opportunity to shape the agenda of the Equal Employment Opportunity Commission, or the EEOC, over the term of his presidency. That will come through some new appointments, including designation of the new chair and the general counsel. The current general counsel, who will be ending his employment with the EEOC this month, that was announced previously. He just let us know yesterday that he's going to be joining a plaintiff-side law firm in Washington, D.C. That primarily handles class action litigations on behalf of employees. Not a huge surprise there. But that will give the president-elect the opportunity to appoint a new general counsel to the EEOC, and as well as during the course of the presidency, he'll also have the opportunity to appoint 5 members of the commission who will all need to be replaced by 2020. Just recently, the EEOC had issued its strategic enforcement plan. This was back in October of 2016, and essentially the plan was to eliminate barriers in recruitment and hiring, specifically to protect vulnerable workers such as immigrants and migrant workers. The EEOC wanted to address equal pay issues, preserving access to the legal system, harassment, and discrimination, and we anticipate that the Trump administration may, through these new appointments, attempt to shift the direction of the EEOC, shift the strategic plan away from those selected discrimination and harassment topics. One way that the President could try to divert the EEOC's efforts is through a reduced budget. This would essentially eliminate the EEOC's ability to engage in enforcement activities or greatly reduce it. During the Obama administration, what we saw was the EEOC conducting investigations routinely in discrimination and harassment matters, but really only going forward on large cases against large employers that it thought it could get the most play out of in the courts and in the media. And so even if you were a small employer that had a charge that the EEOC found some merit to and conciliation efforts didn't pan out, it was very unlikely for small employers that the EEOC was going to pursue that action any further and would just issue the right to sue letter to the employee. It is unlikely with a reduced budget that the EEOC would be able to continue those efforts of going after large companies and large employers because those investigations certainly take time and take money and effort. And so we may see a change in direction there. It could also potentially lead to a decrease in discrimination litigation at the federal court and state levels for employers of all sizes. Although in some cases states may decide to pick up the laboring oar on the investigations, and we certainly do see that through work sharing agreements, a reduced budget will prevent the EEOC from conducting thorough investigations in many of the discrimination cases. So more employees are just going to simply get the right to sue letter rather than going through the full investigation process. And we do see a little bit of that right now. In that case, a lot of times employees either cannot find legal counsel or don't have the funds to pursue their legal action in federal court against their employer and simply just drop their EEOC charge. And so that could be an outcome of reduced budget to the EEOC. We could also see reversal of the new EEO1 reporting requirements. So back in March of 2016, the Obama administration directed the EEOC to collect additional data about the pay of women and other racial and ethnic minorities from all employers that had more than 100 employees. It would have provided data to the EEOC to assess whether the employer's pay system was equitable, but it also would have provided data to plaintiff-side law firms to use in lawsuits against those employers in the future on behalf of those employees. So it was supposed to go into effect September 30th of 2017, but it's possible that we could see the reversal of the EEO1 reporting requirements through executive order by President Trump.
Thanks, Lauren. You know, it's interesting, just like the EEOC, the National Labor Relations Board has been much in the news over the last 8 years, and much like the EEOC, the National Labor Relations Board has taken a more aggressive approach through rulemaking and reversal of precedent. And clearly, the NLRB over the last 8 years has been can be determined as a worker and union-friendly board. So what can we expect from the new board? Well, let's take a look at where we are right now. Currently, the board only has 3 of its 5 members. You've got 2 Democrats and 1 Republican. You've got, on the Democratic side, Chairman Pierce and Member McFerrin, and on the Republican side, you have Member Mishimura. President-elect Trump, or President Trump, once he's inaugurated, will have the right to immediately nominate individuals to fill the 2 vacancies that currently exist at the board. He will also have the right to designate the new chairperson at that time. Haven't really heard the names of individuals being floated yet as potential nominees, so don't have any insight on that at this stage of the game. What is interesting is that even after he fills those, the current vacancies, he will also be faced with other potential nominations in a relatively short period of time. Member Mishmira's term expires December of 2017, and Chairman Pierce's term expires August of 2018. So within the next couple of years, he'll have the right to appoint up to 4 members. Additionally, General Counsel Griffin's term expires late 2017. I believe it's in November. So the President-elect will also have the right to appoint a new General Counsel. In almost every other election, you presume that the party that wins is going to appoint the majority of members of the board and the new General Counsel. So we would expect a 3-2 Republican majority once the vacancies are filled. What's interesting is that, again, generally you can predict where the newly constituted board is going to go. Under the Obama administration, with a 3-2 Democratic majority, it was clear that the board is going to be pretty union-friendly. We think that will be the case with the Republican administration as well, that it will become employer-friendly rather than union-friendly. But it was interesting that during the campaign, there really wasn't much said about the National Labor Relations Board or issues during the campaign. And what makes it a little bit interesting is the fact that many blue-collar union workers deserted the Democrats during this election and backed President-elect Trump in states such as Ohio, Michigan, and Pennsylvania. So, again, we don't have as clear an idea as we might have in prior elections, but the prediction, a fairly easy one to make, is that this will be a much more employer-friendly board. The changes at the NLRB in terms of changing what has occurred during the Obama administration is not going to happen overnight, though. It's going to take a little bit of time because, for 2 factors, really. One, at the regional level, the regional director, the regional attorney, and the regional staff are likely to still be philosophically aligned with the current board. And then secondly, before the newly constituted board can overturn some of the things that have been done, these cases are going to have to work their way through the standard NLRB procedures of the issuance of a complaint, a hearing, appeal to the board, etc. So, although changes are expected, it's unlikely that they're going to happen real quickly. But we do expect certain areas of the new Trump board to consider changes. For example, the BFI, Browning-Ferris Industries of California case, that established a new joint employer analysis, making it much easier, quite frankly, for the board to find joint employer status. We expect that that is something that will be looked at very closely by the newly constituted board. Similarly, class action waivers are a hot topic that will be looked at under cases such as D.R. Horton and Murphy Oil. What's interesting with the class action waivers, though, before the NLRB gets a chance to decide that issue or to change that issue, it may actually get resolved by the Supreme Court. Because there is a circuit split on the validity of class action waivers, there are petitions for cert presently pending before the Supreme Court, and that actually may be heard before any changes occur through the NLRB. We also anticipate that the new board will look closely at the specialty healthcare decision as it relates to the formation of micro units. We also anticipate that a new board would be very much less inclined to expand Section 7 rights in areas such as handbooks, social media, and confidentiality policies. And then another area that I think a new board and a new general counsel will look at would be partial or intermittent work stoppages. General Counsel Griffin is of the view that partial and intermittent work stoppages in most situations are subject to Section 7 and should get the rights protected by Section 7. I would anticipate that a new general counsel would take a much different view of that. In addition to the fact that the Labor Board may make some changes to things like the joint employer class actions, etc., we also anticipate that there may be some legislative action by the Republican Congress to either modify or repeal certain decisions, such as the recent quickie election rules that the board promulgated, and possibly, too, to overturn the Browning-Ferris joint employer analysis. But again, these things will take time, but obviously these are issues that will be looked at very closely, and I think it's clear there will be a sea change as it relates to the board's position on a number of these issues. As the last bullet point on this slide, I did want to mention something that I read from a couple of commentators who said that it's possible that President-elect Trump may consider not filling the vacancies at the board, basically freezing the board out of being able to change any policy because of a lack of quorum under either the Noel Canning case or New Process Steel. I presume he would do that only to delay or to stop anything by current board members who have a Democratic majority. But I found it to be kind of an interesting position or an interesting query, but I doubt if that's going to happen, but thought I'd raise it in any event. Lauren?
Okay, so next we're going to move on to the topic of judicial appointments. As everybody knows already, we lost Justice Scalia back in March of last year, and since that time, Merrick Garland has been up as the nominee, President Obama's nominee for Justice Scalia's seat, and the Republicans in Congress have refused to confirm him or hear his confirmation. So what we'll have is once President-elect Trump is inaugurated, he'll have the ability to put forth nominees for the Supreme Court position. What we've seen, he's put out a list of approximately 20 potential nominees. This was a list he put out during the election and has since stuck to that list. We know that they are very conservative individuals who will likely follow the positions that Justice Scalia has taken, and that's certainly what President-elect Trump has said that he would do, is appoint somebody who would continue in Justice Scalia's footsteps. There has been a little bit of chatter that the Democrats could try to filibuster any Supreme Court appointment made by Donald Trump, but with the majority that they have in Congress, the Republicans would have the ability to take the filibuster right away through rulemaking, and so it's possible that could happen, but unlikely. So what we're going to see is a restoration of the 5-4 conservative majority to the Supreme Court, but that won't necessarily change anything major in the short term because not all of the decisions that we saw, even with Justice Scalia being present, were 5-4 decisions. So one way that Donald Trump will have the ability to further impact the court and change that the tenor of the court is if Justice Ginsburg or Breyer were to either retire or pass away during Donald Trump's term as president. In that case, we would see the appointment of one, if not possibly two, more conservative justices, which will certainly change the direction of the court. Ruth Bader Ginsburg is currently 83, and Stephen Breyer is currently 78. So, certainly a possibility. One area where the Supreme Court could have an impact is with public sector labor unions. So we saw a decision during this term where the court declined to say that public sector unions could require or could not require employees to join the unions, and we could see a reversal of that decision during the next Supreme Court, even with a 5-4 majority. Expect a reversal of that, so they won't be required to pay dues in states that are not right to work. And as Hank mentioned, another area for employers where we could see a decision that will significantly impact those that use class action waivers and arbitration agreements in employment contracts. There's a currently a split on the circuit court level, and we could see the Supreme Court take that up next term. Now, even the prior Supreme Court, with Justice Scalia on it, was very arbitration-friendly, even though employee-friendly at the same time. So it's possible that with the addition of a new conservative justice and possibly more over President Trump's term, we could see an additional decision in favor of class action waivers and further favoring arbitration agreements under the National Labor Relations Act. And finally, there are also 103 federal vacancies. President Obama has nominated 59 candidates for those vacancies, and we could see a situation where either President Obama tries to appoint those justices prior to the end of his term during a recess from Congress, or if they're unable to be appointed, Donald Trump will have the ability to go in and make those appointments and directly shape how the lower courts are going to be deciding issues. So, for example, the D.C. Circuit, who decides most of the Labor Relations Board's appeals, could be dramatically changed by some new additions from the president-elect.
Thanks, Lauren. Let's talk about minimum wage. Obviously, during the campaign, there was some inconsistency by the president-elect as to his position. Sometimes he supported it, sometimes he opposed an increase to the federal minimum wage. What is clear is that, given the Republican majorities in Congress, it's unlikely that any increase to the federal minimum wage is going to get a lot of traction. What's more likely to happen is that the issue is going to be left to individual states. What we've seen and will likely see a bit more of is activity at the local level. For example, very recently within the city of Chicago and the county of Cook, there have been ordinances passed to increase the minimum wage within those jurisdictions. We anticipate that we're going to see a lot more of that coming from various localities, since you're not going to get the big push on the federal level. In fact, in the latest election, just held last month, voters in 4 states approved increases in minimum wage. So we're likely to see that kind of activity continue. The new or potential Secretary of Labor, Andrew Puster, he opposes the minimum wage, particularly a raise to $15 an hour. He doesn't object necessarily to rational increases, but those would be much smaller than what some others have proposed. What's interesting is he, too, has indicated that he thinks that minimum wage issues should be left to either the states or the individual localities, making the point that you may need a higher minimum wage in San Francisco than you do in Sacramento. So we don't see any kind of a push on the federal level, at least, to increase the federal minimum wage, but would anticipate that we will see a fair amount of activity in the blue states and on the local level. Similarly, we don't expect a big push for a nationwide right-to-work legislation. Support of right-to-work is part of the Republican platform from their convention, but I don't anticipate that we're going to see a big push for a nationwide legislation. Again, it's likely that this will all be left to individual states and individual state voters to make the decision. Clearly, Vice President-elect Pence was a strong supporter of the Indiana statute, but again, I don't think that will translate into a push for legislation at the federal level.
So the Department of Labor was one area where early last week I could have told you a little, and now that we know that Andrew Puder is going to be the Secretary of Labor under the Trump administration, I can tell you a little bit more. What we do know about Mr. Puder is that he's the CEO of CKE Restaurant Holdings, which owns entities such as Hardee's and Sledz Jr., and he's also a former attorney. He's been very vocal during his time as CEO and prior to that on what his positions are with respect to different labor policies. And as Hank mentioned, with respect to minimum wage, we know that he's opposed the increase to $15 an hour and said it really should be left up to the states. We know on the overtime rule that the Department of Labor had set to go into effect on December 1st, but was recently enjoined. He said that it diminishes opportunities for workers, and he's against it. And on joint employers, as one can imagine, because entities such as Hardee's and Sledz Jr. Have franchisees, he's got a particular disdain for the joint employer positions taken recently by the Department of Labor and the National Labor Relations Board. Of course, he won't have the ability to impact the National Labor Relations Board stance on joint employers, but certainly will be able to direct how the Department of Labor is going to pursue such action. So the overtime rule is something that we've been getting a lot of questions about, so I wanted to give everybody an update as to where we are with that. Just recently, just last week actually, the Fifth Circuit agreed to expedited briefing on an appeal that was brought up by the Department of Labor to the Fifth Circuit after the injunction was entered. This is the rule that would have increased white-collar exemptions from $23,660 to nearly double, $47,476 per year. So again, the Department of Labor filed its notice of appeal, and the Fifth Circuit agreed to expedite the briefing. We anticipate briefing will be concluded by the end of January, and that we're going to hear oral argument on the case sometime shortly thereafter, so in February or early March. But that being the case, certainly Donald Trump will be inaugurated in January and will have the opportunity to then make his appointments effective. So it's possible that the Department of Labor could decide to drop the appeal, which is likely, and drop any kind of opposition to the injunction. So we shall see how that plays out. Now, it's not necessarily the case that the overtime rule will never be implemented in any form. It's completely possible that we could see a revised rule that maybe increases the white-collar exemption slightly, but not doubling it like the new rule would have done. So that's certainly something that may be a possibility on the horizon, but nothing set in stone yet, and I wouldn't expect anything coming out of the White House or Congress on the overtime rule, certainly within the first 100 days or any time shortly thereafter, so you can likely expect a status quo for a while. We could also see a change in policy through administrative interpretations and rulemaking. The current Department of Labor has done a lot of that, and we anticipate that Mr. Puzder will try to reverse some of the interpretations and rules that the past Department of Labor has made, and that, again, could include the joint employer relationship as well as independent contractor status. And then, of course, as we saw with the EEOC, another thing we may see with the Department of Labor are reduced investigations and a reduced enforcement budget. That will certainly benefit employers, especially on the independent contractor status issue. If you're in the technology industry or the on-demand industry, that was going to be a hot topic moving forward and less likely of one now that we will see a change in administration.
As we mentioned earlier, President Obama had some stiff resistance from Congress, particularly in his second term, as he tried to advance his agenda to help the American worker. Because of that, President Obama used executive orders extensively, and what we've done on this slide is list out some of the ones that we felt were important. And again, he had to do that simply because he could not get his agenda through the Republican-controlled Congress. So a lot of executive orders that applied to labor and employment issues. Some of them had pretty significant impact on federal contractors, such as EO1 Reporting, which called for up to 56 hours of paid leave annually, or EO 13658, which called for a minimum wage of $10.20 an hour for federal contractor employees. There were also certain executive orders that attempted to codify, if you will, positions taken by other federal agencies. For example, EO 13665 basically provided that employers could not retaliate or discriminate or discipline in any way employees who discussed their wages and shared information as to their compensation with coworkers or outside parties, which basically adopted the view taken by the National Labor Relations Board that those are protected discussions under Section 7. Likewise, under EO 13672, federal contractors were prohibited from discriminating against employees or applicants on the basis of gender identity or sexual orientation, which, again, basically codified the position taken by EEOC that it is advancing or attempting to advance before the courts right now. We told you at the very beginning that there might be some hesitancy on our part to make rock-solid predictions because we were trying to figure out exactly what was going on with the President-elect and some of his thoughts. This is one that I think we can, with some certainty, say that we would expect that all of the above executive orders, all the ones that we've listed on this slide, are either going to be revoked or substantially modified, and these can be revoked or modified as of day one. So we anticipate that there will be pretty swift action to modify or revoke these executive orders.
Okay, and the last area we're going to cover is paid leave. During the campaign, President-elect Trump had tried to get more women on board with his campaign, and part of the way that he did that was by announcing support for paid leave programs. And so one of the areas that he said that he would support paid leave for is paid maternity leave for mothers. Now, originally, the paid maternity leave would have only applied to married mothers, but he's since changed his position and said that it would apply to single and married mothers. And he's also said that he supports paid sick leave for employees. And with the paid maternity leave, he supports 6 weeks of paid maternity leave, but it wouldn't be necessarily paid for by the employer. What President-elect Trump proposes is that for those employees who do not have paid leave already provided by their employer, and currently only about 20% of employers do provide some kind of paid leave for expectant mothers, they would be entitled to apply for unemployment for those 6 weeks where they would not be paid. So it's not necessarily full pay because, of course, not everybody receives their full weekly benefits under unemployment, but it would be some form of paid leave. As of this point, it doesn't appear that the plan for maternity leave would also include paternity leave. Of course, employers would still be able to provide that kind of leave to their employees, and we've seen a trend over the past several years where many employers have decided to do that. And in the past, with respect to sick leave, the President-elect has said that employers should provide paid sick leave for full-time employees for a sick family member or for during the birth of a mother. So it appears that there is some support there. Now, it's unclear whether, although he supported these positions during the campaign, he will actually continue to support them when he becomes president. Again, this is one area where there may not be significant movement during the initial 100 days or even sometime thereafter, although if he wants to retain the support of the female voters that he attracted through these policies, he may place a little bit more priority on them. But as of right now, they seem to be lower down on the priority list. You can continue, though, to expect advancements in paid leaves at the state level. over the past essentially year to a year and a half, we've seen numerous local entities as well as statewide initiatives for paid leave for illnesses, and we anticipate that will continue despite any federal or lack of federal initiative for paid leave in the workplace.
Before we go to questions, I'd just like to make one comment. Due to time constraints and the fact that Lorna and I did want to reserve some time for questions, we weren't able to cover all of the federal agencies that may be impacted by the President-elect's wishes and policies. So things like OFCCP, things like OSHA, we didn't get a chance to discuss, but the overriding theme is that obviously this administration is going to be more business-friendly than the prior administration, and we anticipate that we're going to see much less in the way of regulation. As a matter of fact, I believe the President-elect has said that for every new regulation that's imposed on business, he wants to see 2 drop off the table. So it's clear that just like we're seeing with EOC or NLRB or that we're predicting we're going to see, you're going to see similar changes with the other federal agencies that unfortunately we didn't have time to get to today. So with that, perhaps we can take some questions.
Okay, we can. Our speakers will now take your questions. As a reminder, to submit a question, go to the chat pod located in the lower left-hand corner of your screen. Type your question in the available box and click on the Send Submit button. We do have a question waiting. What is the future for the DOL's, quote, persuader rule under a Trump administration?
This is probably a question that Laura and I will fight over to answer because it's probably one of the easier ones. The persuader rule obviously is the rule that would have required disclosures by employers and their consultants if the consultants had any direct or indirect contact with employees where the object was to persuade employees to not join a union, for example. That rule, which was pushed hard by the Department of Labor, was, like so many other rules, has been enjoined by the federal court. And given the fact that it's been appealed, but we don't expect any kind of a decision prior to the inauguration. So given the appointments that we've seen at the Department of Labor, given the fact that, again, President-elect Trump wants things to be business-friendly, I'm fairly confident saying this is dead in the water.
Okay. Well, just as a reminder, you can type your question in the available box there in the bottom left-hand corner and just click on the Send Submit button. At this point, there do not seem to be any other questions. You guys have done such a wonderful job of covering everything.
Well, thanks to everyone. We've put up the address for our blog. Please feel free to register for that and check it frequently. There's no cost to it. We are constantly updating it, and obviously anticipate that there will be a lot of updates that will be coming over the next couple of months. So please visit our website frequently. And again, thanks to everybody for your attendance today.
Thank you very much, everyone.
Okay, that completes our presentation for today. We hope you have enjoyed a new administration, what's in store for employers. For CLE or HR credit, please click on the evaluation link that is now displayed on your screen and complete for the certificate of attendance. Please allow 4 weeks after the program to receive it. Thank you for your participation, and we look forward to having you back for other events in the future. That evaluation link is now displayed on your screen. Everyone have a wonderful day.